Thank you for joining us today. My name is Richard Samp. I am Senior Litigation Counsel here at the New Civil Liberties Alliance. We're here today to discuss a federal canon of statutory construction known as Chevron Deference. That doctrine, which the Supreme Court has recognized since the early 1980s, states that a federal court, in at least some circumstances, should defer to a federal agency's reasonable construction of an ambiguous federal statute, even if the court concludes that a different construction is a better interpretation of the statute's meaning. The New Civil Liberties Alliance, which is committed to upholding a strict separation of powers among the three branches of government, has been a leading critic of the Chevron doctrine. We believe that when a court defers to an agency's interpretation of statutory construction, it is abdicating its responsibility to say what the law is, and also it violates a litigant's due process right to a hearing before an impartial tribunal. The Supreme Court's commitment to Chevron deference appears to have been waning in recent years. Several justices, including Justices Thomas and Gorsuch, have become vocal critics of the doctrine. The court has not invoked the doctrine at all in about 7 years, when it has been interpreting the federal government's, whether it has been passing on the federal government's interpretation of a federal statute, and two pending NCLA certiorari petitions ask the court to overturn Chevron or at least significantly cut back on its application. The court is obviously paying close attention. It has been holding on to those petitions for months, even though they have been fully briefed, and even though the court generally will rule on a pending petition as soon as it has become fully briefed. But so far it has not yet agreed to hear either of those cases. With me today are two lawyers who played major roles in preparing NCLA certiorari petitions. On the far right is John Tienken, a litigator at Cooper Kirk, a preeminent Washington appellate litigation boutique. John, along with name partner Chuck Cooper, who, by the way, is a member of NCLA's board, served as counsel of record for NCLA in its cert petition in Petitions versus Garland, a challenge to a regulation issued by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, or ATF. The regulation purports to interpret a federal statute defining machine guns. John graduated from the University of Chicago Law School with high honors and with a certificate in business leadership. Before joining Cooper Kirk, he clerked for Judge Andrew Oldham of the Fifth Circuit and Judge Amul Thapar of the Sixth Circuit, both of whom are bright new stars on the federal appellate bench. In the middle is Roman Martinez, the deputy managing partner of the D.C. office of Latham and Watkins, and a partner in the Supreme Court practice. Roman was the principal author of NCLA's certiorari petition in Buffington versus McDonough, which challenges the Department of Veteran Affairs' interpretation of a statute governing veterans' disability benefits. Based on that interpretation, NCLA's client, Thomas Buffington, was denied substantial disability benefits to which he would otherwise have been entitled. Before joining Latham, Roman served as an assistant to the Solicitor General and as a law clerk to Chief Justice Roberts and to then Judge Kavanaugh when he was sitting on the D.C. Circuit. Roman has argued 11 Supreme Court cases, including 2 victories last term. Welcome to both of you. In both of these 2 cases, the lower courts applied Chevron deference to the agency's interpretation. They concluded the underlying statutes were ambiguous and upheld the agency's interpretations as reasonable, even though not the only plausible interpretation. John and Roman will be discussing our two pending cert petitions in particular, and the future of Chevron deference in general. But before we get into reading the tea leaves, I'd like to place Chevron into a larger context. Recent Supreme Court cases and decisions indicate that the court shares many of NCLA's concerns about maintaining the separation of powers, and in particular about preventing the accumulation of too much power in the executive branch. So I'd like to begin by asking each of you to describe for me some of the other areas on which the Supreme Court has focused and how Chevron might fit into that larger overall scheme. So, Roman, do you want to start off?
Sure, and thank you, Rich. It's great to be here with NCLA. John, great to be here with you as well. It's been a real pleasure partnering with you, Rich, and with Mark and Kara and the NCLA team on the Buffington case. I think it's really important to take a step back when thinking about Chevron and understand that the court's thinking in this area is really, in the Chevron context, is really about a broader set of concerns about administrative law that, as Rich was saying, NCLA has tended to share. I think, as we all know, Congress every year legislates, but it doesn't legislate all that often. I think every year Congress passes about 100 to 200 laws. But federal agencies are enacting each year 3,000 to 4,000 regulations. And so in the real world, if you just think of like where our law comes from, it's quite different from everything that you and I learned when we were being taught how a bill becomes a law when we were kids. And really, there's a huge amount of authority, a huge amount of power that's being exercised by federal agencies. And I think the court in recent years has been concerned about that. And they've been thinking hard about a number of different doctrines, including Chevron deference, other deference doctrines. When should we defer to agencies like I guess you would call it Kaiser deference or our deference when you're deferring to agencies when they're interpreting their own regulations. The court has been interested in issues of ensuring that the President of the United States has control over federal agencies in an appropriate way and maybe cutting back on the independence of certain agencies that Congress set up to be independent of the executive branch. There are other doctrines as well. The major questions doctrine is one that came up this year. But I think the general gist of what the court has been trying to do is sort of express a bit of concern that the balance has gotten out of whack and that agencies are exercising too much authority. And there are a bunch of different tools, doctrinal tools that the court has in thinking about those issues and thinking about how to cut them back. And so I think that this has been a major issue, especially for Republican presidents and the justices that they've nominated. Justices Gorsuch and Kavanaugh in particular had spoken a lot and written a lot about these issues as lower court judges. And I think there's reason to think that Justice Barrett might share some of their concerns. So I think this really is a hot topic for the court, this whole area of law, Chevron being one very important piece of it.
And John, I know that you've been directly involved at the Supreme Court on one of the areas Roman was talking about, and that is making sure that the president has complete control over the entire executive branch. Can you perhaps elaborate a little bit on what you have been doing and what is at issue there?
I think one of the major issues that has popped up in the Supreme Court in several cases recently is removal restrictions on administrative agencies, in particular on the head of agencies, to make sure that when a president is elected, if the individual is going to be exercising executive power, that the president can remove them. And Cooper and Kirk was involved in a case that was decided last year involving Collins and the director of the Federal Housing Finance Agency. And so I think what we're seeing is, I think Roman mentioned, a constellation of different issues where the court is really involved in setting out the limits for the administrative state, and I think resetting the boundaries in which it's going to be able to operate. And I think, and the upshot is, a lot of these are attempts to make it more accountable and more consistent with the Constitution.
All right, John, now I'd like to get into a little bit more of the particulars about the two NCLA cases that we're here to discuss in the context of Chevron. You were involved in drafting our brief in the Petitions case. Can you give us a little bit of background about that case and what arguments we are raising with the court?
Yeah, absolutely. So I think the best way to think overall of the Petitions case is like many admin law cases. It's really a case about who decides and various permutations of that question. So the issue, as Rich was mentioned in the introduction, is ATF's regulation making illegal bump stocks, which are a component that can be added to different semi-automatic firearms. And I think we can think about it, we need to back up a bit and look at the statutory history to kind of understand how we got here. In 1934, Congress passed a law imposing steep taxes on what it defined as machine guns. And this is essentially an effort to make sure that they could take gangsters off the street, because if they were using machine guns, they probably weren't paying taxes on them. Fast forward 50 years later in a gun reform legislation in 1986, and this largely criminalized civilian possession of machine guns going forward. And the definition of machine gun hasn't changed since 1986. In the early 2000s, many components, devices known as bump stocks, came on the market, and the ATF sent out essentially classification letters articulating to the public how it was going to treat these bump stocks. And for certain bump stocks that were built with certain springs, it said these are it eventually came to the conclusion these were machine guns. But it said that non-mechanical bump stocks are not machine guns and are lawful. And our client, Mr. Petitions, purchased a bump stock, on the understanding that ATF would view them not as machine guns, but as legal components to have. After the tragic mass shooting in 2017 in Las Vegas that involved a gunman and a bump stock, the Trump administration began a formal rulemaking and issued a regulation that said that a bump stock is in fact a machine gun, and made them all illegal and ordered individuals to turn them over, destroy them, and they can't purchase them going forward. In our case, Mr. Petitions claims that ATF didn't have the statutory authority to do that. In the district court, the government said, we do, and that's based off of an unambiguous reading of the statute, that machine gun just covers bump stocks. And whatever you do, court, don't go to Chevron. We don't want Chevron, we don't need Chevron. And the district court agreed with the government that bump stocks are unambiguously covered in the statute, and it didn't decide the Chevron question. We go up to the panel, and a divided panel says, we know you didn't want Chevron. We know you didn't ask for Chevron. We know you didn't cite Chevron. We're going to give you Chevron because this is ambiguous, and we would like to defer. And NCLA made the argument, whoa, Chevron can't apply. This is a statute that has criminal implications. You're redefining what is unlawful. And the panel says, no, in fact, a Supreme Court decision involving the Endangered Species Act made it clear that Chevron does apply to criminal, to statutes that involve criminal applications. We go up to the 10th Circuit, and that case ends up being dismissed and providently granted, with 6 voting to dismiss our petition and 5 judges dissenting. And they made very compelling arguments that there's no reason, if the government doesn't want Chevron, for Chevron to apply. And certainly, Chevron shouldn't apply at something as important as a statute that involves criminal applications. So those are essentially, that's the setup of the case. And our petition raises whether or not the government can waive Chevron, whether Chevron's even applicable to criminal cases, and if it is applicable, maybe, or should the rule of lenity, which is another doctrine that applies to ambiguous statutes, apply instead.
Thanks, John. Now, we then later had the Buffington case come into the office, and my thought was, well, we'll kind of model our cert petition after the petition that we filed in a potion, and we'll try to nibble at the corners of the Chevron doctrine, and also try to use that as another vehicle for cutting back on Chevron. And so I spoke to Roman about it, and he said, "Oh no, I mean, why just go just a little bit? Why not go whole hog and file a petition that says let's overrule Chevron completely?" So why don't you tell us a little bit about the Buffington case?
Yeah, so the Buffington case, I think, is the subject matter of the case is a little bit less exciting maybe than John's case, but I think equally important in terms of its implications for administrative law. So our client, Thomas Buffington, served in the Air Force. He finished up his active duty service, I think, in 2000, and was diagnosed with a disability, and at which point he became immediately eligible to receive disability benefits. And there's a federal statute that requires the government to pay disability benefits for veterans who qualify. So he was receiving these benefits, at which point he was recalled in two different instances over the following decade to active duty service. And there's a different statute that says that you cannot simultaneously receive disability benefits and active duty pay. So for the period of time in which he was serving in active duty, he should not have been receiving the disability benefits. He informed the proper authorities, so he was not being double paid. So fast forward to when his active duty ends, Mr. Buffington doesn't immediately request the resumption of his disability benefits. He waits a couple of years for whatever reason, and he then says, "Oh, you should have turned back on my disability benefits because the federal statutes are very clear. I'm entitled to these benefits. The only exception to when I'm supposed to get the benefits is when I'm on active duty. So here's what you owe me. Please, pay me the money." And the Department of Veterans Affairs said, "No, that's not really how it works because we have a regulation that we've enacted. And the regulation says that you're required to ask for your disability benefits to be turned back on after you finish active duty service within 1 year. And if you don't do it within that 1 year window, then the most you can get in terms of retroactive disability benefits after your active duty service concludes is 1 year's worth of benefits." So you have the agency stepping in and by regulation essentially enacting a kind of forfeiture rule, a deadline, which has very significant real-life consequences for veterans who everyone agrees are entitled to their disability benefits so long as they're not serving in active duty. So the case is brought, I think, before NCLA and Latham got involved. It was litigated in front of the Board of Veterans' Appeals. Our client did not prevail. It was litigated in the Veterans Court. Our client did not prevail. And then it was litigated in the Federal Circuit, and our client didn't prevail. I think at that point NCLA had filed an amicus brief, but we were not yet all joined up actually representing the client. And the Federal Circuit essentially says that we aren't going to rule in favor of the veteran because of Chevron deference. It says, look, the statute doesn't have a time limit, and that's a gap in the statute, and that means that Chevron deference applies to the agency if it has a reasonable construction of the statute, and here the agency's construction is reasonable. So it's a very Chevron-centric ruling, and it rejected the argument that Mr. Buffington had made, which was that if you read these statutes together in a way that makes the most sense, the best reading of the statute unambiguously supports his side, number one. And number two, even if you think that maybe it's a close case, there's an important canon of construction, which anyone who does work in the veteran space is very familiar with, which is the pro-veteran canon of construction. It basically says, and has been around, recognized by the Supreme Court since World War II, it says that if there's interpretive doubt, if a statute's not entirely clear, it needs to be read in favor of the veteran because we essentially assume that Congress wanted to protect veterans. And the Federal Circuit said, no, we're not going to apply that pro-veteran canon of construction at step one of the two-step Chevron inquiry. We're just going to go right to deference. So at that point, Rich and NCLA got engaged, and then Rich generously invited me to join the team. And so we decided to kind of put together the cert petition. And as Rich was saying, the issue that I think has been very neatly teed up for a while, and that for those of us who do a lot of work in the veteran space is really one of the most important administrative law questions in veterans law is this question of how the pro-veteran canon intersects with Chevron deference. Should you consider the pro-veteran canon at step one of the inquiry before deferring to the agency. And so that was very clearly an issue that we had to raise. And that's our first question presented in the petition. And the basic argument is Chevron itself, footnote 9 of Chevron, which is in some ways the most important line of Chevron for those who want to kind of cabin its scope. It says that before you do any deference, you got to really figure out what the statute means, and you got to apply all traditional tools of construction. We say, hey, the pro-veteran canon is a traditional tool of construction. It has to be applied at step one. And the reason for the reasons the Federal Circuit didn't apply it are wrong. And we say, look, the Federal Circuit's completely confused on this question of how the pro-veteran canon intersects with Chevron. 9 judges have asked for Supreme Court guidance. You should grant cert to resolve that issue. But as Rich said, we also wanted to tee up the more fundamental question of whether Chevron itself should be overturned. And I think that one thing that we've seen, including in the Dobbs abortion case this past year, is that sometimes these questions are not kind of cleanly presented in a cert petition in a way that's 100% clear that the party is preserving a challenge to an existing precedent. We've decided, and this has kind of come up in a couple other cases this year where Chevron was sort of implicated, but it wasn't, the question of overturning Chevron wasn't squarely teed up. So we decided, hey, we're going to make an all-out case. And we didn't spend the entire petition on this, but we spent a good chunk of the petition arguing for Chevron to be overturned for a whole bunch of reasons. And so our petition now has 2 questions presented, and it's in front of the court for decision. And as I'm sure we'll talk about, the court's been sort of thinking hard about what to do.
And John, I think perhaps the same basic issue about which canon takes preference is involved in the Petitions case as well. There is a canon that has been around since perhaps the 17th, at least the 18th century, called the rule of lenity. And arguably that is a traditional rule of statutory construction, and so arguably should take preference over Chevron as well. Can you tell us how that applies in the Petitions case a little bit?
Yeah, the rule of lenity, which I think one judge has said is like as old as time, is one of the most traditional tools of statutory interpretation, and it involves essentially criminal statutes. And if a criminal statute is ambiguous, the courts instruct to read it, with leniency in mind. It's essentially a pro-defendant canon when the law is ambiguous. And so what we have here is a question of, well, we have what some courts have found to be an ambiguous statute making machine guns illegal as applied to bump stocks. And so should they defer to the agency saying they're illegal, or, consistent with footnote 9, apply a traditional tool, the rule of lenity, first in favor of any possible defendant?
Can I just jump in on that, Rich?
Sure.
I think this question of how you apply canons at step one is a really important theoretical question for Chevron deference. One of the ways in which, and we've sort of all been touching on this, but one of the ways in which judges who believe in Chevron but take it seriously, I think of Justice Scalia, although maybe he was turning away from Chevron in his later years, one of his sort of insights as a longtime supporter of Chevron was that it's not like an automatic rule of deference. You've got to take step one of the inquiry in which the court really tries to figure out if there is a better meaning of the statute and what it is. You got to take that inquiry seriously. And that means you got to really interpret the statute just like you would in any other case where you didn't have this potential deference doctrine. You got to apply, you got to look at the text, you got to look at all the other tools of construction that are important to apply, that are normally applied. And I think that lost in some of the rush in some lower courts to apply Chevron deference has been this idea that you really need to do some really hard work at step one before you even think about deferring. And that's why this question of the canons is so important, because canons often are going to help resolve any ambiguity and thereby allow the court to apply what the court believes is the best view of the law and eliminate any need to defer. And that's why I think the rule of lenity, whether you're talking about the rule of lenity or the pro-veteran canon, there are a bunch of other canons out there. It's really important for judges to understand that if we're going to have this Chevron doctrine, you got to have it as a last resort, not a first resort, and you've got to really apply all the tools of construction, including the canons.
Now, the Petitions petition was filed in August of 2021, and it was fully briefed and ready for decision by the court in December of 2021. But then when the case was scheduled for a conference by the court, it was rescheduled to a later conference, and that happened 20 separate times. It was rescheduled 20 times. The Buffington case, we filed the petition in January, and that, I think, was fully briefed and ready for decision by the court, certainly by about the beginning of April. And that case came up for a conference, but it was rescheduled 6 times. And the court normally has a rule that they try to rule on every single pending cert petition that has been fully briefed no later than the end of their term in June, but that didn't happen in these cases. It was held over, and of course nobody knows exactly why the court rules the way it does and why it doesn't hear them, but I think at a minimum can we agree that that means the court is paying very careful attention to these 2 petitions, otherwise it would not be holding them off. Now, there are 2 different ways that the court can defer a case. It can reschedule a case, which is what happened in our case. It also can actually have the case come before one of their conferences, and they consider it, and then they decide to relist the case to a future conference. And maybe one or both of you can perhaps briefly describe the difference between those 2 and what maybe some of the standard thinking is about those differences.
Sure, yeah. I frankly, and I clerked at the court, I then and now continue to find the differences subtle, nuanced, opaque, and a little bit hard to decipher. So it's not totally clear to me that it's that there's a clean explanation, and certainly the court does not have a published rule or explanation of when they will reschedule a case versus relisting it. I think usually when they're rescheduling a case, i.e., rescheduling it for the first conference without actually discussing it at a conference, usually that tends to be in circumstances where the justice or the law clerks have realized in advance of the conference that there's another case maybe raising related issues or the same issues, and really these 2 cases or more than 2 cases should be considered at the same conference at the same time. And so that's kind of like the typical situation when it's rescheduled. So I have a cert petition raising issue X, and then 4 weeks later, Rich files a cert petition raising the same issue, and we're on different tracks for different conferences. But the court usually likes to pick and be very careful about picking which case to take up, and they're very attuned to which vehicle is the best vehicle, and so they'll sometimes sort of put all the cases in the same conference. That means rescheduling them. I think that seems unlikely to be what's going on here, because it seems like there were a couple cases. Our cases don't raise the identical issues, but they're closely related enough that maybe they were going to, the court wanted to consider them at the same time. But it's now had that opportunity. It hasn't done that. So I have other speculations, but we really don't know, and it's very unclear why they would do what they're doing without relisting it. And I don't see why they wouldn't conference it the first time.
Now, one other thing I think we ought to discuss that perhaps just simply adds to the mystery is there were at least 3 cases this past term where there was an opportunity for the court, if it wanted to invoke Chevron deference, or at least to refuse to invoke Chevron deference and explain why. And instead, in each of those cases, it really just ignored Chevron entirely and decided the statutory interpretations based on here's what we think the best reading of the statute is. Perhaps the case that comes to mind where that most prominently occurred was a case that was argued in the court in December, the American Hospital Association case. And the petitioner who was challenging an HHS regulation didn't really push Chevron or the Chevron issue all that much, but he was asked at various times during oral argument, well, maybe should we be considering getting rid of Chevron entirely? And he said, well, however we can win this case is fine with me. So that case was argued in June, and it was not decided until, I think, late May, or excuse me, argued in December. It was not decided until late May, early June. And so maybe something was afoot. It took a long time, but instead Justice Kavanaugh wrote a very short decision that never once mentioned Chevron, and there were no dissents from among the people who might have been Chevron supporters. So perhaps John or Roman or both of you can discuss what do you think was going on there that it took so long? What do you read into that decision?
Well, it seems like, Justice Kavanaugh at that oral argument, said something very similar to what Ramon just said. He asked, the client for the petitioners, is this really a case where we need to take footnote 9 of Chevron seriously? And it seems to be that's what the court did. It took them a while. Perhaps it was a unanimous opinion. Perhaps there were discussions about what to do with Chevron. But I think that case, and then the other Medicare case where Chevron may have come up, which is Empire Health, which was a 5-4 decision by Justice Kagan. Both cases don't cite Chevron. Both are very heavy statutory interpretation cases, and it could be that this term the Supreme Court has decided to model what it wants Step 1 to look like without expressly saying that.
Yeah, and I think a couple of things. On the American Hospital case, it's interesting. The lawyer for American Hospital Association was a former boss of mine, former Solicitor General Don Verrilli, who's a great Supreme Court advocate. He was a Solicitor General in the Obama administration, and I think, I don't want to put words in Don's mouth, but I think he's probably a supporter of Chevron deference in general. And I think in that case, they correctly realized that this would be an opportunity to, they could win on the statute. They didn't need it. The government would need it to win, but Don didn't think he needed to overturn Chevron in order to win the case. And I think that's an example of why it was important for us in the Buffington case to really tee it up in a major way. Because if you look at the briefing in American Hospital, it's very in the weeds of these very detailed, intricate Medicare, Medicaid statutes. And it didn't engage with the very important sort of fundamental questions of whether Chevron was right or wrong. And so that's one of the reasons why in Buffington, we agreed that it was so important to kind of tee it up in a way that the court would take the case and it would be a clean vehicle to take it up. I think the only other thing to say on those two cases is this is a move the Supreme Court has been doing a lot. As Rich mentioned, they haven't, I think, relied on Chevron in 7 years, the Supreme Court. And so the Chevron doctrine is kind of like, maybe kind of dead in the Supreme Court in the sense that they're not actually applying it. But that doesn't really solve the problem because it's still the precedent. And so you've got lower courts out there that have to take Supreme Court precedent seriously. And there's a recent study that was done by some law professors who have sort of pointed out that there's kind of like a Supreme Court version of Chevron where it's ignored. And then in the lower courts, Chevron is applied. And I think it's 3/4 of cases involving agency regulations where those regulations are being interpreted, Chevron is invoked. And the agency tends to do quite well when Chevron is on the table. And so I think that the idea that the fact that the Supreme Court is not really applying the doctrine is, for those of us who may be more skeptical of Chevron, is probably a good thing in each individual case, but I think doesn't solve the problem of getting this doctrine off the books or at least modified in a way that lower courts can really stop sort of blindly deferring.
And I think perhaps the American Hospital Association case itself is a good example of that. The D.C. Circuit, by a 2-to-1 vote, had upheld it and did it even though they recognized there were good arguments in support of the challengers by saying, well, but there's at least one argument in support of the government, and so we throw up our hands immediately and apply Chevron. And is that something that you're saying occurs regularly in the lower courts?
Yeah, I mean, I just think the lower courts, sometimes these agency cases are very complicated. The statutes are dense. It takes a lot of work to figure them out, to apply all the canons if you think that that's how step 1 of the inquiry should work. And I think there's a bit of a sense that, okay, well, Chevron means that the agency gets to decide legal questions. And so if it's a hard legal question, let's just see what the agency says and do that. And I think, that doesn't happen in every case, and different courts and different judges are different. But in general, that's sort of like where the doctrine pushes judges. And it's not a great place if you think about the rule of law, because really, you have litigants to a case essentially saying that I have the power, even though I'm the litigant in the case, getting to decide what the law means. And that's not really consistent with due process of law. It raises real questions about taking judicial authority away from judges and courts. And I think that's why Chevron is problematic.
All right, and let me just play devil's advocate on that issue for a second. I think that supporters of the Chevron doctrine would say, well, look, Congress wants Chevron. Congress passes a law. It says we are going to delegate to ATF the administration of the various firearms laws, and we're going to explicitly say that ATF has authority to issue rules and regulations that enforce the statute. And inevitably, there are going to be new situations that arise that weren't thought of at the time that the firearms laws were first passed. I think you said in 1934, John, and therefore, it's reasonable to assume that Congress wanted the agency that is administering the statute to be the one that figures out how to resolve these ambiguities. So if that's what Congress wants, what's wrong with it? So perhaps you can tell me why there's something wrong with that, John.
Well, Rich, I think channeling Justice Kagan's majority opinion in Kaiser, where she upheld our deference, and one of the arguments that she brought to bear on that is saying our deference has been around for a long time. Congress has passed a lot of statutes, and they've never told us we were doing it wrong. So maybe this is just the way we should keep doing it. And I think, an unconstitutional law is unconstitutional when it's passed. I think there's a lot of constitutional arguments for why Chevron is wrong in the first instance, in particular because the judicial power is vested in the judiciary. Congress can't arrogate it from the judiciary to an executive agency. And I think also Ramon mentioned there's some due process problems. You're putting a thumb on the scale of the government, who is a party, in most of the litigation involving Chevron. So even if Congress could pass that or did pass that statute, I think it's still, we still have these constitutional problems. And because the Supreme Court has told the lower courts time and again that it's the only court that can decide when a Supreme Court precedent is no longer binding, the Supreme Court can't allow this bifurcated Chevron, not for us, but all of you need to continue to follow it. And that's why I think these two petitions raise questions that still need to be addressed, even if the Supreme Court is allowing Chevron to kind of die slowly.
All right, you've convinced me that maybe
you're a pushover, Rich.
Maybe Chevron isn't so great, but let's look at the rule of lenity for a while. Yes, that rule has been around for a long time, and that means that ties go to the criminal, and we don't apply it. And okay, if I'm willing to accept that,
defendant, he's not a criminal necessarily.
Okay, so we
the unjustly accused defendant.
So we defer to them. But your old boss, Justice Kavanaugh, recently said, "I think the rule of lenity ought almost never to be applied, that the rule of lenity is when you have an extremely ambiguous statute. But come on, judges, your job is to go out there and to really, really look hard and look at every piece of evidence and figure out what this statute means. And so maybe we ought not to be applying Chevron all that often, because we really ought to be working hard, but we also ought not to be applying these other canons that are just based on presumptions rather than language in the particular law. So why really should we ever be applying the rule of lenity at all?
Yeah, so I think that raises a good and interesting question, which is very distinct from the Chevron question. I think the Chevron question, as John was sort of saying, is like sort of who decides. And the skeptics of Chevron would say, look, you've got questions of law, both for constitutional reasons and under the Administrative Procedure Act, which specifically says that relevant questions of law have to be decided by courts. The decider needs to be the court. And so that is the Chevron question. Once you get to the court, and once you are the court, or you're sitting there as a judge trying to figure out what the statute means, then the question is, well, what are the rules that should apply when I'm trying to figure out what the statute means? And there, I think there's a wide range of reasonable arguments that different canons. I think the pro-veteran canon is, of course, ironclad and can never be challenged. But since I'm not dealing with the rule of lenity case, there are arguments on both sides. What exactly is the rule of lenity? What is the trigger? Does it have to be grievously ambiguous? That's the formulation that my old colleagues in the Solicitor General's office like to use because they're the government. Or is there some lesser standard of ambiguity? And I think there's a fair range of debate, canon by canon, about maybe the canon shouldn't be a canon. Maybe it should apply in this case, but not in that case. But I think that's just a fundamentally different question from the sort of Chevron who decides question.
All right, and then going back to the Chevron question, John, one of the issues you raised in the Petition case is what happens when the government offers an interpretation, but they say, oh, we're waiving it, we don't want it to apply here. Now, several federal appeals courts, not only the 10th Circuit in the Petition, but also the D.C. Circuit in another court case called Guades, said, we're not going to pay attention to what the government says. Our obligation under existing precedent is to apply Chevron whenever it is applicable, and if, in fact, the government has offered an interpretation, it's our obligation to follow that interpretation of an ambiguous statute so long as it's reasonable. Why is the 10th Circuit and why is the D.C. Circuit wrong on that?
Yeah, well, I think the waiver question is interesting because it kind of shows all of the problems that Chevron leads to. So, for instance, in a earlier case around 2013, City of Arlington, the Supreme Court said that part of the Chevron deference question is deferring to a certain subject matter that the agency says it has regulatory authority over. And in a waiver situation, what the agency has said is we don't have a gap to fill. We don't have this authority here. We're just reading the statute as it is. So if you actually take Chevron doctrine as it's developed seriously, Chevron requires deferring to an agency decision not to have deference. It's kind of this crazy world that we get into. In particular, what has happened is the lower courts are very inconsistent on waiver. For instance, if a plaintiff, a private party, doesn't bring up Chevron in their briefing, it can be forfeited. They won't give that private party the benefit of Chevron deference. But now, in the D.C. Circuit and these other circuits, if the government does it, no, they still will anyway. So it's yet another thumb on the scale. So I think for many reasons it doesn't make sense, but it's also applied inconsistently based off the party, creating even more kind of these due process flavor problems.
Well, that sounds like the sort of issue maybe the Supreme Court ought to grant review on if there's a conflict among the circuit. Yeah. All right, with that, I've been told it's time to wrap up our discussion and to open it up to questions. And I'm wondering if we have any questions at the moment. Go ahead.
We do. So Stephen Dewey, who some of you may know, is asking the following question. He says, I've heard the reason that SCOTUS is avoiding Chevron deference cases is because the Chevron doctrine was applied in 107 cases from 1986 to 2016. And does that number seem correct to you guys? And also, do you agree that this may well be preventing SCOTUS from addressing Chevron cases, and specifically preventing it from ruling against the Chevron doctrine in new cases? Does the sheer weight of past decisions
Yeah, so maybe I'm happy to jump in on that one. I think one of the real stumbling blocks for those of us who are interested in having Chevron overturned is that it is in fact a precedent of the court. And so one of the things that we have to deal with in our Buffington cert petition expressly asking them to overturn it is not just explaining to the justices why the decision's wrong, but also explaining why it's so wrong or so problematic that it needs to be overturned anyway. So I think I agree with the questioner's sort of insight that the fact that it's been around for a long time and it's been applied in many cases by the Supreme Court makes it harder. On the other hand, as we've seen, the Supreme Court is willing to reconsider precedent in appropriate circumstances, and we think that this is in fact an appropriate circumstance. Not only is Chevron egregiously wrong, but unlike some other precedents that sort of resolve one discrete issue, Chevron has a kind of system-wide effect. It's sort of like it exists in perpetuity, and it applies to, in theory, to almost any statute that's interpreted by any agency. And so it kind of generates new erroneous interpretations and erroneous legal decisions over and over again in perpetuity. And we think that's like a uniquely Chevron-specific problem. I also think that there are workability problems with Chevron. There's questions about how ambiguous does a statute need to be to trigger Chevron. Those are hard to figure out, hard to apply in an even-handed fashion. You have the fact that reliance interests, which usually reliance weighs heavily in favor of keeping a precedent on the book, that doesn't really apply to Chevron in the same way because the Supreme Court has said that agencies can change their positions. So if you actually apply Chevron to something, what you're saying is that the law doesn't actually mean X forever. It just means X for now until the agency changes its mind. And so you can't, as a regulated entity, you can't necessarily rely on that in the same way you could in a normal context in which a precedent is there. So I think for all these reasons laid out in our petition and elsewhere, like we think there are good reasons why, even though the Supreme Court has applied Chevron a lot of times, even though it's been around for a while, why we think a proper application of the stare decisis considerations would warrant overturning it.
And I think, as you were pointing out, the regulation of the VA that we are challenging has been around for a while. On the other hand, in the Petitions case, am I right, John, that was a total reversal of a long-standing position of the agency?
Yeah, it was a total reversal, at least over a decade when they issued the regulation in 2018. And I think that you have the Supreme Court, when they had the chance to overturn our deference, which is deference to an agency's own regulations, they didn't do it. And Justice Gorsuch, writing for 4 justices, said that the majority flinched. And so I think I think the Buffington petition makes compelling arguments, and we make compelling arguments for chipping away or getting rid of it and ensuring that the majority doesn't flinch when it does take up this question.
Yeah, I would ask anybody who has a question, make sure they get the microphone brought to them. Go ahead if you have a question, Mark.
Thanks, Rich. So, Ron, you alluded earlier to the fact that you may have some additional theories as to why the court is holding back. So I hope you'll share those at some point. But I have a different question that I wanted to pitch, which is, it seems like there's a disconnect between the Supreme Court and the lower courts. The Supreme Court hasn't decided on this basis for 7 years. The courts of appeals not only routinely reach out and apply Chevron, but as the Petitions case shows, they do it promiscuously, even when the parties are saying, no, we don't want anything to do with Chevron. And that really puts parties in a bind, because you're not just arguing against whatever arguments the government's putting out, but you also have to worry about, is the court going to raise Chevron sua sponte? So you almost have to argue against yourself as a party in these kinds of cases. And I guess my question is the Supreme Court, are they aware of that? Do they understand this terrible dynamic that's taking place? And why are they, given that, why are they continuing to ignore Chevron so assiduously?
All right, jump in first, sure.
Yeah, I think raised a very interesting point, and one that Chief Judge Timkovich raised in his dissent from the en banc, and he called Chevron kind of like a Lord Voldemort precedent. It's the case that shall not be named, but that party can't afford to do that if the court's going to raise it sua sponte, and so it's always lurking in the background.
Yeah, and I think one of the weird dynamics here is that when these Chevron cases do get to the court is kind of doing the right thing, right? It's just like looking hard and doing good statutory analysis. I think if you look at the competing opinions, or the Kavanaugh's opinion and then Justice Kagan's opinion in the 2 healthcare cases from this term, you could agree or disagree with them, but methodologically they seem to be doing exactly the right thing. And so we need to find a case where they can do that kind of analysis, but first can just kind of clarify the rules and say that this is really the only thing that courts down below need to be doing. On the speculation point, Mark, I don't have any good reasons or good informed speculation. I guess the one thing that does jump out to me is this was just an enormous term that just concluded at the court. And they had to deal with a lot of big cases, including big cases involving whether to overturn precedent. And it's possible that the court wanted to just kind of kick a decision down the road into the fall so that it wasn't getting hit with the overturning of Roe versus Wade, and then that same day the court's announcing that, oh, and by the way, we're also going to be potentially overturning Chevron. That might be an optimistic interpretation. It suggests that they kind of are willing to grant cert. They just want to wait a little bit. But that's my hopeful interpretation.
All right, sir, you go next.
In the regulatory bureaucracy that we see in America and the view of the common American man about regulatory overreach, I often wonder if the court looks at this in the American viewpoint, that this is part of what we consider draining the swamp to stop something like Chevron from over-empowering the abuse of regulators on the common citizen.
Either of you want to take that?
Well, I think when you're considering applying Chevron in the criminal context, it asks a lot of the ordinary citizen. Justice Gorsuch, in an opinion, wrote that it essentially asks the ordinary citizen to make 3 guesses. The first guess is whether the statute will be found to be ambiguous by a court. The second guess is whether the agency's regulation will be considered reasonable. And the third guess is whether, after an election, the agency is going to change its mind and whether that regulation will be reasonable. That creates a very high standard for citizens to be informed of what is a violation of the law or not.
Yeah, and I would say, on your question about the bureaucracy, my thinking on Chevron has evolved sort of since law school, but one thing that really helped crystallize my own personal concerns with Chevron was when I was in the government. I was a government lawyer in the Solicitor General's office, and one of the things that we would do is we would talk to different agencies, because we were thinking about legal strategy, appellate strategy for the government, and sort of talk to them about their legal interpretations, the arguments they were going to be making in briefs, whether they were strong or weak. And one thing I kind of learned by doing this over and over again is one of the things that Chevron does is it incentivizes and sort of trains agencies to think not in terms of what the law actually is and therefore what their constraints are, but rather, what is it reasonable for me to argue? And once you sort of once you tell agency lawyers that, don't worry about what's right, just worry about what could be defended as reasonable, you've suddenly given the agency a lot more leeway and running room. And so I'd be having these debates with the agency lawyers, and they'd be saying, well, yeah, that might be wrong, but it's reasonable, that's close enough. And I think that's not a healthy incentive in a government of laws to have agencies essentially being told by courts that this is okay. I mean, one of the things that always struck me is if you take the Chevron sort of doctrine really seriously, you could have a situation in which the agency concludes the better reading of the statute is X, but it's really close between X and Y. Even though the better reading is X, we're going to go with Y because that's reasonable. The judge could think the exact same thing. The better reading is X, but Y is kind of close. And everyone in the case would think that X is the best reading of the statute, but nonetheless, the court has to apply Y because of this doctrine. And something's wrong with this picture if that's the sort of result where everyone agrees that X is what the law is, but instead we're going to apply something other than that. That just doesn't make a lot of sense to me. And that's why I think the Chevron doctrine really just has these fundamental problems with it.
So in the course of this discussion, the rule of lenity was characterized as giving the tie to the defendant. But this is not the understanding of some people, like, for example, Gorsuch's concurrence in Wooden v. U.S. or Judge Bibas's concurrence in Nasir. And they say it's a thicker canon. It applies to, as you alluded to, not even just egregiously ambiguous, but sometimes it dictates our entire frame of interpretation. Should that matter for Chevron purposes? Is there something special about a thicker rule of lenity or veterans canon that dictates to us when it should apply step 1 or step 2, and does that matter?
My short answer is I think if it's a real canon, which I think both of these canons are, I think they should definitely apply at step 1. That doesn't necessarily mean that it's going to necessarily get you all the way home. It kind of depends on how you view each individual canon. But I certainly think if this is a real thing, then I think you got to apply it at step 1 for the reasons that are made clear in footnote 9 of Chevron, which is you got to take account of all tools of construction.
Well, and I think consistent with that, what we're and animating both of these canons is an idea of fair notice to citizens, and I think consistent with Chevron is that Chevron I think impedes that fair notice because of all the guesswork and how reasonable statutes may be. So I think both of them are consistent with traditional tools of statutory interpretation and the concerns we all have about the abuse of Chevron.
Kara?
So towards the end of this term, when those 3 cases were coming out that we were talking about, that everybody this is the Chevron case, this is Chevron case, and sort of by the end, West Virginia versus EPA, if you were following legal commentary, there's a whole set of people that think if Chevron gets overturned, rivers are on fire and buildings are going to crash. But what's the actual practical effect of overturning Chevron? I mean, how do you think this plays out if cert is granted either now or eventually and Chevron is overturned?
I mean, my view is that it's a really important, the effect is extremely important as a theoretical matter for kind of restoring constitutional principles of the rule of law and the separation of powers and due process. So that is like a very significant thing to accomplish. And if that's the only thing that happens, that's enormously significant. I think how it plays out in terms of do agencies like stop winning cases, I think that's going to depend agency by agency. And the nice thing that overturning Chevron is going to do is it's not going to put a thumb on the scale in favor of this interpretation or that interpretation. It's just going to say that courts need to do in this context of agency rulemaking and agency law what they do in every other context, which is they read the statute, they apply the traditional tools, they get to the best answer that they can come up with, and then they apply that. And so it's kind of a default to like what courts do in every other context. And in some cases, that might be good for regulated entities. In some cases, it's going to make things tougher for them. But I think that just then puts the spotlight, if we don't like the results that we're getting, back where it should be under our system of government, which is on Congress. And then they can write a different law that says, actually we want things to work differently. So that's what I think those results are all salutary.
Yeah, I agree very much with that. I mean, one of the things that getting rid of overturning Chevron and of also limiting the administrative state is it increases accountability, I would think, on Congress, because Congress, as many people have written, may actually like a regime where they can delegate. They can pass a big law that says we should have clean air. No one's against clean air, and then when the agency does it right, they can take credit for it, and if it does it wrong, they can run against the agency and say that's not the law I passed. So we need, by bringing the administrative state, by overturning Chevron, it may actually increase democratic accountability.
I know we're running.
Actually, Rich, I'm going to cut you off. We have so many questions. This is such an interesting thing, and we're actually ahead of schedule. We're going to keep taking questions for right until our 1:15 stop time. If that's okay, I know that Roman has to literally disappear. He'll turn into a ghost at that moment, but I think we have another question. So let's just keep going. This is great.
I have a bit of, I guess, devil's advocate question, and I want to kind of ask you, how do we thread the needle when to potential skeptical courts or skeptical judges when they ask us something along the lines of like, well, how do you draw the line between substantive rules and procedural rules when oftentimes they can bleed into one another? So I'll just give you one quick example. A while ago, I was helping a friend of mine with certain immigration stuff, and there's a procedural rule where basically U.S. authorities say we will not accept photocopies of documents to prove your case, only originals. But that can very much become substantive because if you, for one reason or another, don't have access to originals, you only have an access to photocopy because of one issue or another, you may not be able to get a benefit to which Congress said that you are actually entitled to, whether it's citizenship, green card, or whatever else. So, and how do we deal with that when Congress does not write that thing into the statute? Simply says like, look, if you meet these criteria, you get the benefit. And the agency says, unless you can show us these documents procedurally, we will not adjudicate the case in your favor. Do they get deference on that? Is it substantive rules, is it procedural rules, and how do we draw that line?
Well, I think, I'm not familiar with that specific context, but I think in general, what courts are looking for in this context is whether or not, for instance, in West Virginia v. APA, whether the agency has seized a certain ambit of power with vast political and economic consequences, what it's calling a major question. In the non-delegation context, it's whether or not Congress has appropriately delegated authority, and many times, I think many of us would think they haven't done that, right? And so there may be some areas, certain procedural functionings within an agency, which are these small gaps where they're allowed to do those types of things. But it sounds like there may also be, some other constitutional overlays on that, other than delegation, that may, prevent an agency from creating some type of procedural rule. That's what the due process clause is trying to prevent if it's being abused or used the wrong way, I think.
Yeah, I don't have a lot to add. I think it would really depend on the specific context and what could be sort of implied by the statutory scheme. But I think that wherever you fall on that, the answer can't be that, well, this is a pure legal question that I, as a judge, am not empowered to answer. Instead, the agency gets to decide the answer to this pure legal question. I think that can't be the right way to ultimately think about it. But I think in any particular case, you just need to know the details of the rules that we're talking about.
So another question from one of our online viewers. Anthony has a question about whether overruling Chevron would limit this seesaw back and forth of agencies changing their interpretation of the statute every time a new administration comes into power. Is there anything in a stability context that will be gained by overruling Chevron?
Yeah, so this is a point that is made in our cert papers in the Buffington case. And so we sort of address this in the context of reliance interests. And we make the point, and I think Richard Pierce, who's a very well-known administrative law scholar who had previously been a supporter of Chevron, has now come around to the other position because he thinks that this is actually a destabilizing rule of law. Because on these major questions of policy, you have agencies coming in under a new president, completely changing their interpretation of the statutes, thereby disrupting the statutory scheme that's in place. You can see that in things like net neutrality, immigration, climate change, et cetera. I think that those are good reasons to think that Chevron are, unhelpful, just as a practical matter. I think if you were to overturn Chevron, you're still going to have different agencies coming in and taking different legal positions. But ultimately, the courts are going to be able to provide a little bit more of a ballast to the system, because when the courts are asked to resolve these questions, they're going to decide what the statute means. And if they say that the statute means this one thing, the agency is not going to be able to trump them by changing its mind. And I think that will ultimately, over the long term, create stability.
There is a particularly pernicious form of Chevron deference called brand X deference, where even if a court has interpreted the statute and decided what the best meaning is, unless that it was a really strong interpretation and they said that the government's the view that the government later takes is totally unreasonable, they will apply deference to an agency that comes forward later and says, pay no attention to that court decision. Our new interpretation is entitled to deference. And I think that is a particularly destabilizing effect. And so getting rid of Chevron would get rid of brand X deference as well and would promote stability.
So speaking of overturning Chevron, in your opinion, what would a case that would totally get rid of Chevron look like?
Buffington, it would look exactly like Sorry.
Because I mean, I guess it's more realistic to limit the scope, but I mean, I'm not sure, considering all the stare decisis issues. In your opinion, even, let's say, they don't grant cert in Buffington, they don't go that far, even if they want to limit the scope, where should they start? What's like the best way to kind of start the process of maybe just getting rid of Chevron?
So first of all, I think on what does a case look like, I said Buffington kind of as a joke, but it's not a joke. We make the argument in our petition that Buffington totally tees up this issue and that it's a nice, clean vehicle. We think Buffington's an especially good vehicle because sometimes these Chevron cases come up on matters that are like very politically contentious, whether it's guns or climate change or immigration. We actually think that the right way to, a good context in which to examine whether Chevron actually makes sense is a context that's a little bit more dry and technical, like the administration of the Veterans Disability Statutes. And so we think we actually have a great case to set up that question. Taking that aside, though, other than overturning it, I think that both of our cases there are a bunch of different avenues that you can kind of ways to come at it in which you can limit Chevron. One is to apply the canons more rigorously at step one. Another is John's point about like sort of limiting the ability of the government or of courts to apply Chevron over the objections of the government. And there are other kind of like ways. And so I think there are a number of different cases that will present different questions. To me, the step one question and really confirming that footnote 9 of Chevron means what it says, and you got to apply all the canons of construction. Other than overturning Chevron, I think that's the most important principle to kind of enshrine. I think both of our cases like help do that. But I don't know, John, what do you think?
Yeah, I agree with that, and I think another way of limiting Chevron is also to reduce it to not applying criminal applications. I think that's a very significant restriction of lower courts' ability to defer to agencies if it doesn't apply in criminal applications. I mean, there's no other instance where a court defers to what a prosecutor says the law is, and so that would be another way to limit it if the court were uncomfortable, overturning it.
And the final example, I think, is the major questions doctrine, which the West Virginia versus EPA case, which sort of not only chips away at Chevron in the sense that it says that when you have a major question, we're not going to defer to the agency. It even goes further than that and says, if you got a major question, we need a clear statement from Congress for a court to believe that this power was actually delegated to the agency at all in the first place. So I think there are all these different doctrinal ways to kind of limit it. And you can't do that in one case. You got to deal with it in a number of different cases, like ours.
Yes.
R2 could be the pointy edge of the spear there.
I think one difficulty in a lot of these cases is people challenge Chevron, but then the court says, but we don't have to address it because the government is so clearly wrong that of course we're just going to rule against the government. So the best case is one where there's at least a little bit of ambiguity, arguably, in the case, so that the court feels obliged to address Chevron. And that's always a danger in our cases because we're so obviously right that the court might rule for us without reaching it. But we always have to kind of say, well, maybe we're only 99% right, so overturn Chevron.
Okay, well, so we have a follow-up online. Susan wants to know, okay, major questions doctrine. What does the current tide that seems to be in favor of non-delegation, what does that augur for the court's action on Chevron? Are they just using these other things to nibble away at Chevron and they're never going to admit it, but Chevron is just going to be a sort of chewed-on corpse that everyone has to kind of step over? Or and specifically, how does non-delegation play into this? I know you said major questions doctrine,
Yeah.
but
I sort of view this as a kind of kitchen sink type approach by some of the justices who are concerned about administrative law overreach, and there really are there are a lot of different ways at this problem. We talked about presidential authority over agency officials. We talked about Chevron, major questions doctrine. Non-delegation doctrine is yet another kind of tool in the toolkit, and not just one that's being invented. It's one that's there, I think, fairly in the Constitution itself. So I don't think these are mutually exclusive.
Last words.
All right. With that, I think we really do have to wrap up. We're getting late, but I want to give, first of all, say thank you very much to John and Roman for their fine presentation.
Thanks for having us.
Thank you. Thank you. But I do want to give each of you one last opportunity. If there is some great thought that you haven't had a chance yet to say, to go ahead. Otherwise, we can just wrap it up.
I just want to thank you, Rich, and NCLA for having us and for getting us all involved in these interesting cases. And I guess we'll all just have to pay close attention in late September when the court, regroups after the summer and hopefully is ready to jump into these issues with us.
Okay.
Yes, thank you, Rich, and thank you, NCLA, and thank you all for coming. And I think we'll just pay attention to the long conference in September. So
Fingers crossed.
fingers crossed.
All right. With that, we're wrapping up. Please stay tuned in August for our next Lunch and Law presentation. Thank you.